I was totally thrown off just now by you saying that.
Who are you going to be sentenced by?
I was under Colleen, had a car accident, I do believe. So I wasn't for sure who the judge was going to be today, but I have sentencing today.
Right.
It threw me off this morning. Yeah.
Right. Okay. So are you represented by the public defender in that case?
Yes.
Do you wish to be represented by the public defender in this case?
I don't, it's probably going to be time served with what I got going, I would imagine. I'm just taking a plea for a year.
I'm not promising.
Okay. Right.
So
yeah,
I also don't know if you're being sentenced on a felony. You're in custody now on something else.
I was coming for sentencing today. That's what I thought this was. So
You might want to be careful as to whether or not this does something to your guidelines. It calls the case of the people versus, is it Deja McCoy? I probably mispronounced that, but it's Mr. Bird.
That's the votes of the people.
And good morning, Your Honor. But please, this honorable court.
It's Deja, y'all.
I'm sorry?
It's Deja McCoy.
Deja. Okay. That was nice of you to interrupt, Mr. Bird, but go ahead, Mr. Bird.
Oh, that's all right.
It's okay. It's okay.
We got a good relationship. But Brandon Bird, on behalf of Deja McCoy, Ms. McCoy, can you please state your full name for the record?
Deja Nicole McCoy Yargy.
Thank you.
Respectfully, we'd like to send this matter for a bench trial. Yeah.
A bench trial. Have you signed the form? There's a waiver form. We can get the signature. Ma'am, your attorney has indicated that you wish this matter set for a bench trial.
Yes, Your
You
Honor.
understand that you have an absolute constitutional right to have the matter tried before a jury?
Yes, I do.
All right. You understand that by waiving that right, it'd be tried before this court without a jury present.
Yes, I do.
People also waive their right.
Yes, Your Honor, the people will waive bench, it should be fine.
All right. Based upon the statement of counsel and defendant, court will consent to have the matter tried before without a jury. Non-jury trial will be set September 29th.
I have not had an opportunity to check the dates with my witnesses yet, so I don't know that I could accommodate September 29th.
Gotcha.
But what I could try for that date, if it doesn't work, I could reach back out if there's no objection from defense counsel. Just because we didn't have a chance to discuss ahead of time.
Got it. Okay. That understood, Mr. Bird?
It's understood.
All right. September 29th, I'll set it, and then if you guys need an adjournment, then we'll deal with that. September 29th, 2025, 9 a.m. in person.
That's tentative.
Bond will continue its conditions.
So, what is
Thank you, Your Honor.
Son.
And, good afternoon. Good.
That's it?
Thank you, Your Honor. Court.
Okay.
Yeah.
All right, we'll see you tomorrow.
Yep, see you tomorrow.
Court calls the case, People versus Rick Artuso.
As the votes of the people.
This is Honorable Court, David Burgess on behalf of Rick Artuso, standing to my right.
Your name, sir?
Rick Artuso.
Thank you.
Your Honor, today's the date time set for an adjourned pretrial. He's being sentenced in front of, I believe, Judge Conlon. We'll see if he's there or on the bench or not. Saw him yesterday walking around, but on October 1st, Judge, and I just want to make sure that that's goes smoothly before we resolve this. Yeah, so if we could do adjourn until after October 1st, whatever day is convenient with the court.
There was a sentencing for Judge Conlon?
Correct, October
Okay, I want to make
1st.
sure.
Jonathan Emmons is handling the appeal.
October 15th, 2025, 9 a.m.
Your Honor, could I have, I'm in trial all that week up in Livingston County, so
22nd.
thank you, Your Honor. Appreciate it.
You'd rather be in Livingston?
No, not at all.
Okay, I'm just saying.
It's not a preference, Judge. It's just scheduled.
Okay, all right. October 22nd, 2025, 9.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the People versus Jennifer Gallara.
As the votes of the
Two
people.
cases. 1328 is in the arraignment. All right, go ahead.
Good morning, Your Honor. Marissa Boyles, P86438 on behalf of Ms. Gallara. Please state your name, please.
Jennifer Gallara.
All right. Ms. Galera, before we get to that case, I have to arraign you on another matter. You are citation. You are also before the court on a misdemeanor charge of driving while license suspended, denied, and or revoked, alleged to have occurred on August 11, 2025. The location of Bemis Road in Pittsfield Township, Washtenaw County, State of Michigan. Do you understand the nature of that charge?
Yes, sir.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could also order your vehicle immobilized. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is counsel going to represent you on that, or do you wish to have counsel appointed for you?
My counsel, Your Honor.
She'll represent you on that. You'll file an appearance.
Yes, Your Honor.
All right, very good. So as to the formal arraignment on that, she waives formal
Waive
reading.
formal reading, stand mute.
Defendant waiving formal reading, standing mute, court will enter a not guilty plea. All right, got that. Set bond on that case. I will just set bond in that case at a $5,000 personal recognizance because she's under bond in the other case.
Thank you, Your Honor.
All right. Okay. So what are we doing?
Your Honor, if we could set both of these for the October 15th date, we're seeking a global resolution. So we're going to submit a deviation request and hopefully resolve things on that date. She also has a court date for her hardship license in about 2 weeks. So we're expecting that to be resolved by the October 15th date as well.
And Your Honor, for the record, that driving suspended case does constitute a bond violation. I believe we addressed it at our last hearing, but I wanted the record to be clear that the people are aware that that happened after she was arraigned on the OWI matter.
You did.
Because of the criminal activity.
Yeah, yeah.
All right.
But we addressed it last time.
All right, very good. So I will adjourn both matters to October 15th, 2025, 9 a.m.
Thank you, Your Honor. Thank you, Your
Bond
Honor.
in each case will continue.
Thank you, Your Honor.
Thank you. That's called the case People versus Charles Peters.
Judge Feltus for the people.
Good morning, Your Honor. James Feifelsky appearing on behalf of Charles Peters, who's approaching. Please state your name.
Charles Peters.
Thank you.
Your Honor, Ms. Feltus and I have been in plea negotiations. She'd like a little more time to see my client on the sober link to possibly resolve this. So I'm asking for a brief adjournment.
Correct statement, Ms. Felton.
That is correct.
I'll adjourn this matter October 15th, 2025, 9 a.m.
Thank you.
Bond continues with its conditions.
Thank you. Have a good day.
Court calls the case People versus Reginald Sims.
Judge Feltus for the people.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims. President consents to appear via Zoom. Mr. Sims, can you state your name?
Yes, good morning, Your Honor. Reginald Sims.
Your Honor, date and time
Thank you.
set for a pretrial. I do intend on tendering a deviation request to the prosecutor's office. We are asking for that same date that you've been given out.
During the matter to October 15th, 2025, 9 a.m. Bond will continue. Counsel, you are in receipt of the court's order regarding his testing.
I am, Your Honor, and I understand there might have been an issue before I was retained. We spoke at length about that. It's my understanding he's in full compliance since then.
All right. Very good. That would be his only warning, however, if he fails to test.
Understood.
All right. Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. That's all I have left, but Mr. Bernstein and Sal, but if they're not, can you go see? If they're not ready, tell them I'll call them up in the next block. Mr. Brown, good morning, sir.
Morning, sir.
You ready?
Sure.
Are you? Yeah. Terrapin, am I supposed to beat down on you like we did the house? Is that their mascot?
Yes.
What's the list?
Tigers,
LSU?
a little small school in Maryland. We can't,
The Towson Tigers, apparently.
they're in Baltimore. Shout out to the Tigers.
Somebody needs to shout for
They got paid.
them.
Jet clear.
They need more time. They need more time. All right. Then I'll recall this up on the next block. At this point, court will stand in recess.
All right.
Attention.
Frauds from 2 different establishments. To leave the actual bond. People were to allow them to appear in person to address this bond. For the record, the people do not have a specific request as to bond. We're going to leave the actual bond setting in the discretion of the court, of course, but do want to make a record of a few things. First of all, these 2 cases do involve larceny. They involve retail frauds from 2 different establishments. The first one, the misdemeanor case, involves stealing about $700 worth of shoes from Dick's Sporting Goods, and the other case does involve stealing about $1,700 worth of alcohol and a few household items from minor. They happen about 1 day apart, as far as I can tell. And it's a concern of the people that the defendant was on parole absconder status at the time of those incidents. I'll also note that it is my understanding he has since become compliant with his parole. He is now back and being supervised by parole in Kalamazoo. But it's of great concern when we see things like alcohol and easily resaleable items like shoes being stolen. And I believe that if the defendant can be compliant with bond and any conditions this court sets, that would be ideal. However, if there is any violation of bond, the people will be requesting a remand.
Your Honor, we would like to argue that although this happened while Brandon was on parole, he's no longer absconding. Or while he was absconding from parole, he's no longer absconding. He has appeared in court twice now, over Zoom 2 weeks ago, and in person now, and has driven 2 hours from Kalamazoo to be here today. Also, Brandon has been very communicative with us and very responsive. And he, as we mentioned, he has many certificates that he's received, like front desk operations, to better his chances at employment, which he's currently seeking. So we would like to argue that. Thank you.
Bernstein.
And Your Honor, I echo everything co-counsel said. I would just add that Mr. Nash did complete the KPEP 90-day inpatient program, and he stands before you today sober and proud of his sobriety and wants to continue that.
All right. Very good. With that information and with the information that was provided at the bench conference, I will make one change to his bond. I won't find that he's necessarily in violation of his bond at this time, given that all of those things have occurred that were brought to the court's attention. I will order that he is to test at community corrections. My understanding is he's testing with parole every other week. Is that correct, sir?
Yes, sir.
All right. I'm going to order once a week testing. Right. So there's going to have to be another facility that will do that. My initial order will be that you test every other week at community corrections. However, I will allow you to test at an approved facility in Kalamazoo. All right. So you'll be taking a drug test, short form, you'll be taking a drug test every week. All right. And testing every week. All right.
Yes, sir.
Okay. All right. So on the misdemeanor case, you're seeking an adjournment, counsel.
Yes.
I'll adjourn that to October 2025, excuse me. 9 a.m. And as to the PCC, is there a reason that we need to necessarily keep these together at this point, or?
I don't think so, Your Honor.
All right. What date would you like?
A 2-week adjournment or a 3-week adjournment would be great, Your Honor.
All right. My next one's the 18th. What, the 9th?
Sounds good. Thank you.
October 9th. Probable cause conference in this matter will be adjourned October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue, and that order, as I've indicated regarding community corrections, is going to be entered in both cases. All right. Thank you. When you leave here, I suggest that you go over to community corrections, check in so that you can do the intake portion. Okay. You're in town. Okay. Thank you.
Thank you.
Maybe just wait. I need to.
Court does call the case, People versus Robert Moyle.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Mr. Silla.
Good morning, Your Honor.
For what?
I show cause for failure to appear for them.
Your name, sir?
Robert Moyle.
And this is failure to appear for arraignment.
For Raymond?
Well, hold on a second.
So they said it for a show cause. This is actually a misdemeanor, able misdemeanor category. So failure to respond to the case.
All right. Sir, you have a citation that alleges that on or about February 20th, 2025 at location of Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with an improper registration or plate. You understand that charge?
Yes, sir.
All right. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs.
Yeah, I thought I was.
Understand that?
Yes, sir.
Okay, I don't want you saying anything about the charges. You're in custody now on something else.
I was coming for sentencing today. That's what I thought this was. So I was totally thrown off just now by you saying that.
Who are you going to be sentenced by?
I was under Colleen. Had a car accident, I do believe. So I wasn't for sure who the judge was going to be today, but I have sentencing today. I thought about
Conlon.
Conlon.
So, okay,
Yeah,
so you'd be downtown.
Yeah,
Oh,
see,
right.
it threw me off this morning. Yeah.
Right, okay. So are you represented by the public defender in that case?
Yes.
Do you wish to be represented by the public defender in this case?
I don't. It's probably gonna be time served with what I got going. I would imagine. I'm just taking a plea for a year.
Well, I'm not promising.
Okay. Yeah, right.
So
Yeah.
I
I
also
will.
don't know if you're being sentenced on a felony.
No.
You
Yeah.
might want to be careful as to whether or not this does something to your guidelines.
Oh. Okay.
So I'll ask you again, do you want to be represented by the public defender's
Yeah,
office?
that's best.
Yeah, good answer.
Yeah, I think it's best.
Public defender case.
Mr. Public Defender Natalie Pate with and on behalf of Mr. Moyle, we would waive any formal reading of the complaint. My client would stand mute and we would ask Your Honor for an adjourned pretrial date. And that would be all.
All right. Defendant every way formal reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to October 15th, 2025, 9 a.m. Set his bond in this case at $1,000. I'll give a $1,000, 10%. Depending on what happens in the other case, you can let the court know. I'm just setting a nominal bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court calls the case of the people versus Salvatore Lorenzo.
I suppose it's for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Lorenzo, who's up there on Zoom. Sal, could you please state your name for the court?
Salvatore Lorenzo.
And I don't know if he's been arraigned yet, Your Honor.
He has not.
Well, as far as I go, ask the court to please waive reading, and he stands mute.
Defendant every way from a reading standing mute. Court will enter not guilty plea.
As to the pretrial, I sent Ms. Feltus a letter. I think she's looking into it, and we're talking about a resolution and just need a couple of weeks to work that out, Your Honor.
What I will do is I'll adjourn the pretrial in this matter to October 15th, 2025, 9 a.m. Set his bond in this case at a $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. What was the BAC in this case?
0.168, Your Honor.
Any crash?
My notes have eluded me. I just have 1 second.
Yes.
There was not a crash in this case. The defendant was stopped driving on a flat tire.
All right.
But I would note for the court, there is a count 2 of attempted assaulting, resisting, or obstructing a peace officer attempt.
Understood. So just so that we're clear, I'm going to set his bond at $15,000 personal recognizance bond. I will order that the defendant report over to community corrections for a placement on the sober link testing. I've signed that order.
That's good, Your Honor. We've talked about that, anticipated. He's taken a number of proactive steps in the case so far. So,
all right.
thank you, Your Honor.
Thank
All
you, Your
right.
Honor.
Thank you. Court calls case People versus Gary Neptun.
Ashley Feltus for the people.
Nalepka.
Sam Bernstein for Mr. Nalepka, Your Honor. Nalepka, can you say anything to the court?
Gary Nalepka.
Thank you.
Your Honor, we're asking the court to please set this for a final settlement conference.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025, 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the People versus Ontario Robinson.
Ashley Feltus for the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Robinson. Ontario, can you say your report?
Ontario Robinson.
Thank you.
Your Honor, in this case, my intent is to file a motion challenging some evidence. I'm wondering if the court has specific days that it prefers to hear such motions.
How long will it take? It's a motion to suppress.
Correct, Your Honor.
All right. When can you have the motion filed?
Within the week, Your Honor.
All right. All right. You are filing a motion to suppress by the, by the 24th. Prosecutor's response will be due by the October 2nd. I'll set an evidentiary hearing if necessary on that matter. I'll set an evidentiary hearing for, I'm gonna need a Monday.
You're gonna need a Monday.
And I'm out one. It's gonna be the 20th.
That's jury selection in the morning, so we could do like 11 a.m. in the morning.
11 a.m.
Mhm.
So an evidentiary hearing for October 20th, 2025 at 11 a.m.
Thank you, Your Honor.
I may have a jury trial that day, Your Honor. I may not. I'll just
say here, isn't it?
My jury trial? No, it's a circuit court matter.
All right. Well,
It's being a conflict. Reach out to me.
Okay, thank you. Makes sense. All right. Oh, one more thing. Sorry. A lot going on this morning. Mr. Robinson is asking that the court would please grant a travel request. He's hoping to go to Ohio from Friday of this
God's
week.
sakes, why?
I
Go
know.
ahead, I'm sorry.
I tried to counsel him out of it, Judge, but I was unsuccessful. So he's consistent. But he'd be very much appreciative if the court would allow him to travel to Ohio from Friday to Sunday.
Of this week?
Yes, Your Honor.
For what purpose, you said?
I think his girlfriend has planned a trip for him there. He's on a SoberLink device. You can, of course, bring it with him.
Any objection for the defendant may travel to Ohio When will he be coming back?
I guess he comes
Sunday.
Sunday afternoon, Your Honor.
To the 21st. So he can travel from the 19th to the September 19th, 2025 to September 21st, or yes, 21st, 2025. That's inclusive.
Thank you, Your Honor.
Court calls the case of the people versus Jacqueline Murray.
Ashley Phillips for the people.
Edward Jurgis for Jacqueline Murray.
Your name?
Jacqueline Murray. Mr. Jurgis and I had occasion to discuss this case this morning, and I think we're hopefully getting close to a resolution. I understand Ms. Murray is about to be sentenced into the 14B recovery court with Judge Washington
Okay.
in the next couple of days. So what I'm requesting is that we adjourn this to give her a chance to do that, see how it goes for a little bit, looking at that October 15th date. And I wondered if the court would consider, if Judge Washington releases her, just letting your bond convert to a PR to let her get out.
I will adjourn the matter to October 15th, 2025. I understand that. If Judge Washington releases her, counsel is to let this court know, and then we'll take the appropriate action at that time.
Thank you.
Okay, thank you, Ron.
Thank you, Your Honor.
Thank you. Court calls case people versus Keyshawn Jorgensen.
Right here. Ashley Phillips for the people.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Jorgensen. Your Honor, I believe he's on Zoom.
Sir? Need to
Hey, how
state
you
your
doing?
name and get someplace at your stationery, please.
Yes, sir. My name is Keyshawn Jorgensen. I apologize. I'm at work, but I'm working over here right now. All right, I'm good.
Okay. All right, what are we doing?
Your Honor, he'd like to take it to trial, and so I would ask for trial and a final pretrial.
Final pretrial. Then. Jury final settlement conference on this case will be October 17th, 2025 at 9 a.m.
Your Honor, I'm out of town that day.
Are you going to be out of town Monday if that's jury selection?
No, I'm not. Monday, October 20th. I'll be in town.
Yeah, so here's what I'll do. I'll put jury selection October 20th, 2025, 9 a.m. Otherwise, I don't get this tried to December. So I'll set the October 17th date. He'll need to be here, Frank. However, get with my office regarding whether or not you can appear via Zoom during that day. That will work for you, or that doesn't work either.
Are there any other days?
No, that's the problem. Otherwise, I do something else for you. Counsel approach, please. Very necessary to the 20th at 8:30. I think we found a way to take care of that. Both of those proceedings are in person. Bond will continue. All right.
Thank you, Your Honor.
You're welcome.
Have a nice
Thank
day.
you. Have a good day.
All right. Thank you. Court calls the case people versus Benelli Cruz.
Ashley Phillips for the people.
Carpenter on behalf of Ms. Cruz, who is approaching the podium and will be standing to my right. Ms. Cruz, once you get up here, please introduce yourself to the court.
Good morning, Benelli Cruz.
Thank you.
You understand it's a date and time for pretrial. May we approach for cops?
I know cops, so I don't know why you'd approach.
Oh, I'm sorry. I didn't know.
Oh, you've been here enough. You should know. I don't.
I've never, okay, I'm sorry.
All right, go ahead.
In that case, then, can we pass the matter?
I have, how many more do I have in custody back there?
13.
Well, I'll pass it. I don't know when we'll call.
Understood.
Take her back. Court calls. What's this person named? Court calls the case of the people versus Devin Julia Martinez.
Conrad Soler on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, who joins us via Zoom from the Washington County Jail. Ms. Martinez, can you please state your name for the court?
Devin Julia. I have looked my hair from.
Ms. Martinez, could you state your full name for the court?
Devin Julia. Mr. Martinez.
All right.
Thank you, Your Honor. I'm respectfully requesting an adjournment. Ms. Martinez did indicate to me that she did sign up to be on the waiting list for the In Jail Dawn Farm program.
Okay.
She is being, in order to take advantage of the potential offer in this file, my client is being held on other cases with her next court date being the 29th on her felony cases.
Got it. Okay. Devin, I'm going to adjourn you out to October 15th, 2025, 9 a.m. Okay?
Thank you.
All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Martinez.
Court calls the case of the people versus Abdurrahman Banda.
I'm supposed to people.
I'm volunteering on behalf of Mr. Bonda. Mr. Bonda, state your name, please.
Abdurrahman Banda.
Your Honor, we're here for a bond violation sentencing. I believe you indicated that he could be released to treatment. We're still awaiting bed somewhere.
All right. Was there an order that was submitted regarding this treatment? I don't know if the PD arranged that or not.
Checking. I do show ones. Yes.
One was that. Okay, so we're just awaiting a bed for treatment. All right. What do you want to do today then?
Set a control date in about a week. And then maybe
I
we can
really
take
don't have. I could. Yeah, go ahead. What is that?
So that would be at 1 o'clock.
On which day?
22nd.
What are we going to know on the 22nd that I won't know? I mean, we're trying to get him into treatment.
Yes, Your Honor.
So I could come back in a week and there's no bed available.
He calls our office and I'm trying to make sure that he understands that we're on top of the case, that he's not just sitting.
September 22nd, 2025, 9 a.m. special time.
Thank you. Hopefully we'll have a word for you.
And I think if they contact Patrick, maybe they can figure something out.
Yes.
Court does call the case people versus Andrew Party. Chief Justice.
Conrad Soler on behalf of Pittsfield Township in both cases.
Good morning, I'm Charlotte Steffen on behalf of Andrew Party. Andrew, say your name.
Andrew Party.
Assistant Public Defender Natalie Pate on behalf of Andrew Party, still on the case ending in, 1090.
Got it.
You are?
All right.
I apologize, Your Honor. I believe Ms. Steffen has been appointed to both cases. Is that correct?
That was my understanding, Your Honor, but maybe I'm mistaken.
Do you have that?
I'm double checking.
Because I don't.
So I have her on case ending in 0621.
Correct.
And then PD.
Yeah. So he has two attorneys. All right. So what are we doing on these cases? Because I think the first thing we need to deal with is bond violation. Stephanie, did you get a copy of that?
I did, and I have had an opportunity to discuss that with Mr. Party.
All right, why don't we deal with that?
Sure, Your Honor. So he admits that he has tested positive for amphetamine. He indicates that it's left over from a prescription.
It would be a month and a half long period.
Yeah, that's a lot of amphetamines that he would get possession of. If what he's indicating to you, counsel, is true, Mr. Allen.
I have about 10 more left in my script.
There's also a cocaine positive test.
Yeah, I mean, that.
Yeah.
It was in August 26th. Does he have an explanation for that?
No, Your Honor, he's denying use of cocaine.
He's denying the use of cocaine.
Yes, Your Honor.
So he wants a hearing on that?
Yes, Your Honor.
But he admits to the use of amphetamine without a valid prescription.
I had a scripture. I don't know what you're talking about. I mean, I don't have one. I don't have it with me here.
Is the amphetamine a prescribed medication that he's currently under prescription for?
So, Judge, I think that the issue is that Mr. Party is saying that he was prescribed the medication. I don't know how old the prescription was. These were some pills that he was still in possession of from a prescription.
A couple months ago.
But is he currently under prescribed medication?
I've been taking Adderall since I was 7 years old, so it took 30 years. And this whole incident got me, my doctor cut me off cold turkey. It's just because of this whole thing, but I still had some
The
left.
doctor cut you off, so you shouldn't have been taking it.
Not because he doesn't want to be my doctor anymore. I'm not gonna, I got the paperwork. I'll send it to you. I got this guy right now.
Okay, just so that I'm clear, I thought we were talking about an old prescription.
It is.
So when did your doctor cut you off?
Couple months ago. It's more like he just stopped being my doctor. You got into a thing, and it's just now I have to get a new doctor, CMH, and they're telling me I'm like weeks out. It's not easy trying to get back into it. I had to go through counseling.
Let's try this way. When's the last time you filled that prescription?
It's a couple months ago. And I had my mom hold on to my pills while I was homeless for the time being. Now that I'm back to work and everything else, I got back on them. I wasn't gonna wait till I started school again. It's not easy carrying those around. People keep stealing them. So yeah, I'd have my mom hold on to them. I feel like that's not a problem. I keep it at the house. I don't got a home.
What are we doing with the cases? I'll address this, Bob.
Your Honor, we are asking for an adjournment. We received some additional discovery yesterday, so we need some more time to review.
That's right.
I was going to be requesting an adjournment as well, Your Honor.
A adjournment, and I think the spot is going to open because I believe we have somebody coming from there, coming here into 14th District Sobriety Court.
Set it October 14th, 15th. 1-5? What did you give me last? 15? October 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. I believe you received a community corrections compliance.
He got his warning, and it was very clear and unequivocal. If he has a missed test or a late test again, that he will be spending his time incarcerated.
And I know you explained to him that I only give one warning.
And he has had his warning.
All right,
Thank you, Your Honor.
court does call the case, People versus Lawrence Pack.
Ready, Your Honor.
Ashley Feltus for the people.
Your Honor, good morning. Joe Simon on behalf of Mr. Peck. State your name. Go ahead and state your name. Lawrence Peck.
Thank you, sir.
Your Honor, we're here for an arraignment. With respect to that arraignment, we waive formal reading and stand mute.
Defendant may waive formal reading, standing mute. Court will enter a not guilty plea.
And Your Honor, you may remember we were here last week for a PCC. This was probably supposed to be I shouldn't say supposed to be, should have been a companion matter to that matter. We adjourned that till October 9th so my client could be screened for sobriety court. And I'm asking to adjourn the pretrial for the same purpose. He's actually underway. We thought it was going to be a 14-8 court, but sobriety court, but because of his residence, it's 15th. So he's already made his arrangements. He's going to be screened by 15th District Court. So asking for an adjournment to maybe line up similar dates.
And he's set for October
9th.
Gotcha. You want, so the date after that would be October 15th. That would.
Terrific. Thank you.
No objection. That's all correct. People like to be heard on bond. Appropriate.
All right. Pretrial in this matter will be adjourned October 15th, 2025, 9 a.m. as to bond.
Your Honor, this is an OWI case. This charges an OWI second offense. The prior is from 2023. There was no crash, but there is that prior. The alleged BAC in this case was 0.084. We are requesting electronic monitoring of some kind, given that this is the second offense in 2 years. The reason that there's the companion felony case as well is that there's some RNO attached to the OWI, but we waited for blood to come back on the OWI. So the erupts and the drug got charged first, and then this case is at the same time.
And he's not on any testing on the felony.
Not that I'm aware of.
No, he has been screened and assessed. He's done his aftercare, but I told him to fully expect a referral to community corrections today. He's prepared for that because he's been abstinent, requesting a sober link, Your Honor.
All right. Bond will be set in the amount of a personal recognizance, $10,000 bond. I'll order standard conditions, including no assaultive behavior, possession of any weapons. I'll order there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
I will order it also that the defendant report over to community corrections for placement on a sober link testing device. That'll be 3 times a day. And I've signed that order.
Thank you, Your Honor.
And I'll have him head there directly, Your Honor. It'll take a little bit, I'm sure, but I'll have him do that while he's here.
All right, very good. All right.
Thank you, Your Honor.
Court does call the case of the People versus Jason Eckley.
Ashley Feltus for the people.
Good morning, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel. Your Honor, defendant is appearing by way of Zoom this morning.
Mr. Eckel, can you state your name, please?
Jason Eckel.
All right, got him. All right.
Thank you, Your Honor. This is a date and time set for a pretrial. I've had an opportunity to speak with the prosecuting attorney again. At this time, Your Honor, we've provided to the court a form requesting a final adjournment in this matter. We'd be asking the court to set this for a final pretrial conference. We are continuing to engage in deviation mitigation discussions in furtherance of reaching a resolution. If the court could schedule a final pretrial, we should be prepared by that date. If the court is inclined to set this for October 15th, that does work for defense counsel.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue.
Thank you, Your Honor.
Thank you. And just to confirm, Your Honor, you said October 17th?
Yes, the Friday. That's the final settlement conference day.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Melissa Hatfield.
Ashley Feltus for the people.
Oh, I told you Mr. Bird would show up. No, he's going to be late, but I didn't expect that late. But anyway, go ahead.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Hatfield, who's standing to my right.
Your name, ma'am?
Melissa Hatfield.
Thank you. All right, what are we doing?
Your Honor, we're asking for adjournment. I just learned that there are 2 other videos that Ms. Feltes is going to try to get for us.
Correct statement.
That is correct, Your Honor.
October 15th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Shanice Greer.
That's Feltus for the people.
Ready? Jake Cole on behalf of Shapiro. Shanice? Shanice, state your name for the record.
Hi, good morning. I'm Shanice Greer.
Judge, today's day I'm tape for pretrial. Ms. Greer is in Judge Kuhnke's recovery court doing really well. I asked Ms. Kirsten Stample if we could if it's possible to get this misdemeanor into Judge Kuhnke's recovery court. She said she understands, but she can't do that.
Right.
So we're here today. So my client would just like to set a jury trial date.
Jury final settlement conference, October 17th, 2025. 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Judge, what time is it? I'm sorry, the final settlement conference, 9?
It's the same every time we do it, Gillowall. You pick.
Judge,
which time do you need?
You being the considerate judge you are, I'm just asking the final settlement conference time.
9 a.m.
Thank you, Judge, for your patience. Thank you.
No, okay. Your sincerity is really getting to me. Is that it for you, Mr. Gillowall?
It is, Judge. It's been a pleasure being in front of you. You have a nice weekend.
I won't see you tomorrow.
Oh, yes, unfortunately.
Well, you don't have to look so disappointed. Court does call the case of the people versus Brandon Nash.
Ashton Feltus for the people in both matters.
Right. But do I have
So Ms. Chan and Mr. Bernstein are both here, but not like
with us in spirit.
I mean, physically.
They were physically here.
I don't know what all that. I just don't
They both
have.
kept it.
But they should. Okay. Were you successful?
I was.
Okay.
Sam Bernstein here with on behalf of Mr. Nash, who's in the hallway, and was hoping for a moment to chat with him before he went on the record, if possible.
Okay. So you need me to pass these matters so that.
If I could just chat with him for a moment. We haven't had a chance to meet yet, Judge.
And counsel, any other cases present also?
Yes, they're right there, Your Honor.
Why not? It's your case. It's your parents, huh?
Good morning, Judge Simpson. My name is Melanie Calderon-Lemus, and I'm asking for permission to practice as a student attorney. And
do me a favor. Take a deep breath. All right. Relax. Despite what Sam or anybody told you, you're a very nice person. All right. So go ahead. Start again.
good morning. My name is Melanie Calderon-Lemus. And I'm asking for permission to practice as a student attorney under the University of Michigan Civil Criminal Litigation Clinic. And under MCL 8.120.
You know what? Your professors messed us up. It's all their fault. So you just go ahead. We'll get through this. Go ahead.
So, and under MCL 8.120.
MCL?
Oh, MCR
8.120.
Yes.
Under the supervision of?
Sarah Sallin.
Thank you. Good morning, Ms. Sallin.
Good morning, Judge.
Young lady, I think I asked you before where you're from, right?
Yeah. Yes.
It was Cornell, right?
I went to undergrad there. Yes.
Yeah. And where were you from?
Las Vegas.
That's right. Okay. All right. Are you nervous?
Yes.
Yes. Okay. Would you like an adjournment so you can also speak with your client, or ask the court to pass the matter so you can speak with your client?
Yes.
Good answer. All right, I'll pass these, Kate.
Thank you, Your Honor.
You did just fine.
Thanks.
Okay.
Yeah.
Court does call the case, People versus Benjamin Kritzer.
Ashley Feltus for the people.
Good morning, Your Honor. Brant Lashinsky, PA 4238, Public Defender's Office on behalf of Mr. Kritzer is approaching.
Your name?
Good morning, Judge. My name is Benjamin Kritzer.
Did you almost forget? No, go ahead. Okay.
Your Honor, our assistant prosecutor and I had spoken this morning and yesterday via email. I've been recently assigned to Mr. Kritzer. We're going to ask for one adjournment so we might be able to consider a resolution in this matter.
Without objection, I'll adjourn October 15th, 2025, 9 a.m.
Thank you very much, Your Honor.
Fine, continue. Thank you. I don't need these today. It's okay. Court does call the case of the People versus Justin Katarai.
Ashley Feltus for the people.
Good morning, Your Honor. Oscar Rodriguez for Mr. Katarai, who is available also on Zoom. Justin, can you say your name, please?
Justin Katari.
All right, what are we doing?
Your Honor, we are actually prepared to accept a plea offer. However, we did not get the police report, or this is on me, in time because we need to do it as a no contest plea. So we would like to adjourn it just for one more, as soon as possible. We could put the plea on the record.
I have a date before then, don't I?
October 15th.
That's my next one. Yeah. Oh, that's right, because you wanted time off. All right. My next date, Mr. Rodriguez, is October 15th.
That'll do.
Okay, you don't have to. It's all Miss Weidling's fault. October 15th, 9 a.m. All right. Thank you. Bond will continue with its conditions.
Your Honor.
Court does call the case, People versus Joseph German.
Ashley Feltus for the people.
Good morning, Your Honor, and may it please this honorable court. My name is Jay Dallow, P number 72879, appearing on with behalf of my client, Mr. Joseph German. Mr. German, can you please unmute yourself and state your name for the record? Unmute yourself first. You're muted.
Joseph German.
Thank you, Mr.
Thank
German. And today is a date and time set for a pre-trial on this matter. Mr. German, do we have your consent to hold today's hearing virtually instead of in person? Are you okay with that? We have your consent, sir?
Yes.
Thank you, sir. Your Honor, as I stated, today's date and time set for pretrial. I've been corresponding with Sister Counsel, Ms. Feltus, and I wanted to I want to leave the floor to her to see if we had submitted a deviation. I think we're close to resolving the matter. I yield the floor to Ms. Feltus if there's any offer at this point.
Well, that's not going to be stated on the record, but
Unfortunately, any offer would have to be reduced to writing, so we would not be able to enter it. If there was one available, which there is not at this point, that October 15th date does seem appropriate, Your Honor.
during this matter, October 15th, 2025, 9 a.m.
Thank you, Judge. Is Zoom going to be sufficient for October 15th?
You have to submit the form and then I will make a determination.
Regarding October 15th, may I respectfully request a 1 week adjournment from that to October? Let me see. I'm sorry. I can't even do 22. I'm in trial. Can we do October 29th to return on the 29th?
That's not how my docket works, but when is my next date after that? Limited for October 22nd. I could squeeze you in October 22nd if you can't be here on the 15th.
I would love to. However, October 22nd, I am going to be in trial. Your Honor, I will.
I'll adjourn it to November 5th, he said.
Yes.
Is without objection from the people.
No, none, Your Honor.
November 5th, 2025, 9 a.m.
Thank you so much, Your Honor. Pleasure to see you.
All right,
And
thank you. Yes, sir.
Thank you all.
All right. Thank you. Court does call the case of the people versus Eric Hopkins.
That's close for the people.
Good morning, Your Honor.
Morning, sir.
Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, you state your name when you get up here, please.
Eric Hopkins. Thank you.
Your Honor, the people have extended an offer just this morning. My client does need a little time to weigh his options, so we'd be asking for an adjournment.
During this matter, October 15th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus George Walker.
That's close for the people.
One more time for me, Your Honor.
No, I just did that on purpose.
Robert Ellman with and on behalf of Mr. Walker, who is present over Zoom.
Mr. Walker, can you state your name, please?
George Walker.
In this case, I'd be asking for an adjournment to the October dates, as well as the defendant's bond being denied in this case for the bond violation that is upcoming for the FA.
Your Honor, no objection to the adjournment to the October final settlement conference date. Regarding bond, I'd ask that the court keep his bond as it is. As the court knows, this case hasn't been charged out yet. He hasn't been arraigned on it. If he's going to be held on that case, a magistrate will make that decision when he is arraigned.
All right. What I will do is I will adjourn the jury final settlement conference and jury selection to October 17th, 2025, 9 a.m. for the settlement conference, and jury selection, if necessary, October 20th, 2025 at 8:30. Given the circumstances, what I will do at this point is I will revoke the defendant's bond. And that's based upon the representations pending a hearing on the violation. If you'd like me to set that, then you just let the court know. We will set a violation here. Okay. All right. So ideally, the best thing to set it after the arraignment. Sure. All right. Are they ready? They're ready for the next one. Okay, court does call the case of the people versus DeJure Bond Sanders.
Ellie Zed on behalf of the people, Your Honor.
They weren't ready.
How's it going, Judge?
I want Bird and Matt to wait. Bond Sanders. I'm just letting you know how I feel.
Good morning, Public Defender Lauren Perny on behalf of Mr. Bond Sanders. State your name for the record, please.
DeJure Bond Sanders.
Your Honor, we have come to a resolution. Mr. Bond Sanders is going to plead as charged in this case. This was part of a global resolution that included some felony charges that were up 2 weeks ago at exam. Those felony charges were dismissed and he pled it on a DB there.
And that's correct, Your Honor. That file is coming before Your Honor. I believe that sentencing was adjourned. After the plea in this case, though, Your Honor, the victim is here to request contact. I'm not sure if the court gets on other files. It's still no contact as well. I'm not sure if the court has that file.
I do not have that file with me. Sorry.
Yeah, scheduled for the 18th. Did you say that? Sorry. The sentencing on the first DV is scheduled for the 18th. I assume Ms. Pilara is going to.
I'm going to let her take a look at all of that before I make a ruling on contact on this, just to let you know. I'm going to see my phone. All right.
Your Honor, sorry, before we enter the plea, Mr. Bond Sanders is asking if you'd consider giving him back his phone privileges. They were revoked. I couldn't give you a date, but several weeks ago, given the representations made by the people.
That's right, Your Honor. He was contacting the victim from custody. That's why they were revoked.
Correct. And which was a violation of his bond. I am not inclined to reinstate those phone privileges at this point. Given that everything is coming up, I will take a look at everything come the 18th. Fine. May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give be the truth, the whole truth, and nothing but the truth, so you got it? Lower and then say your name again.
Bond Sanders.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of June 27, 2025, at the location of 2265 Glencoe Hills Drive, Apartment 5, Pittsfield Township, Washtenaw County, State of Michigan, what did you do regarding, is it Natisha Henderson that makes you think that you're guilty?
I threw sand at her.
Pardon?
I threw sand at her.
You threw sand at her, so you threw something at her?
Yes.
Okay, and who is she to you?
That's the mother of my son.
Okay, so you have a child in common?
Yes.
All right. And you didn't have her permission to do that, did you? All right. And you did it intentionally?
Yes.
All right. If I accept your plea and you commit misconduct between now and the time of sentencing as defined by the Michigan court rules, any sentence agreement or evaluation, the court is no longer bound by, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements which have caused this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor. Yes.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation, pre-sentence investigation, and report. He is set for sentencing on that other case on the 18th?
Yes.
Is it?
That's correct.
We can do the 18th.
Yeah.
Pardon? Yeah. Sentencing in this matter will be August 18th, 2025 at 1 p.m. Bond with its conditions will continue.
Thank you, Your Honor.
Right, thank you. Court does call the case of the people versus Ali Hayeri.
Ally Zen on behalf of the people, Your Honor.
Your Honor, good morning, Joe Simon on behalf of the defendant. State your name, Ali.
Ali Hayeri. Yes, Your Honor.
Your Honor, today is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Accordingly move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Your Honor, request that the court check the box returning prints and arrest data.
I don't have the. I don't have a dismissal.
Okay, I can prepare one for the court.
That's fine.
Thank you.
Court calls the case people versus Robin Muhammad.
I'm sorry.
Oh, they just called for him.
Ally Zen on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad.
He's coming out. I may have called it a bit early. Weidling, why was he up there trying to talk to you?
Oh, Mr. Simon? He always talks.
No, this one. I'll talk to him. Don't talk to him. You can talk to Joe. Talk to him. Ramin Muhammad. You just came up there. He looked like he was up to something.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad. State your name for the record, please, sir.
Rahman Mohammed, thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Thank you.
Court calls the case People versus Kiera Peterson.
Haley Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Sachs on behalf of Ms. Peterson's and son.
What?
And son.
It's on? Okay.
Unfortunately, she wasn't able to secure child
what?
care. She wasn't able to secure child care. We know this is a dismissal.
Want me to punish her for bringing baby?
Absolutely not. He's Jewish.
Okay. All right. I didn't know what you want. How old?
10 months.
10 months? Oh. See, now I can be in a good mood.
That's what I said.
Huh?
I said the same thing.
I know. I'm a sucker for babies. But don't everybody be bringing you.
I was like, I'm always having a baby on my hip for now on.
Because some of them don't know how to behave. This is much like my staff. All right.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, defense miss for dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, sir.
Thank you. Court does call the case People versus Elizabeth Raggett.
Conrad Silver on behalf of the Township.
Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Raggett. Ms. Raggett, can you please say your name to the court?
Elizabeth Raggett.
She's going to enter a plea
Yes, Your Honor.
to OWI. Is that correct?
Yes, Your Honor.
That's correct.
All right. May I have her sworn?
You solemnly swear or affirm testimony you're about to give truth, whole truth, and nothing but the truth, so help you God.
I do.
Lower your hand and say your name again.
Elizabeth Raggett.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
Do you still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today
No, Your Honor.
to get you to plead to this?
Right.
Sorry.
I understand.
Has anybody threatened you or coerced you?
No,
You're doing this voluntarily?
I am.
Of your own free will?
Yes,
And because you believe that you are indeed guilty of this offense?
I am, Your Honor.
On the date of March 27, 2025, at the location of Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
I did.
What did you have and how much?
I had about almost 2 bottles of wine.
All right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I pulled out, and I misjudged, and I went directly into another vehicle. I was trying to turn left. I'm really sorry.
Did the police arrive?
They did.
Were you taken to the hospital?
I was.
And was there a blood test?
There was.
And the blood test was 0.191?
Yes.
All right. Do you have any reason to dispute those blood tests?
No.
Ma'am, you understand that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and any sentence evaluation or recommendation, the court would not be bound.
I understand, Your Honor.
Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
August 27th at 12.
August 27, 2025, noon. All right.
Could I just bond, Your Honor?
Yes, you may.
Ms. Raggett has, she's been in jail for 3 weeks now. Obviously, tell by her demeanor that candidly she has struggled with alcohol. That's something that she's very well aware of. She knows that she needs help. She had signed up for the Trinity Addiction Services program prior to her incarceration. It was a 3-day-a-week program that would involve counseling and group sessions, and she thinks would be really beneficial for her. We talked about the plea form, and specifically if she were to be given the privilege of release, any sort of drinking behavior would likely result in jail incarceration rather than probation. So she's pretty well aware of that, Your Honor. She has pressing family concerns that she's hoping to get back to in the world, an ill father, and a son as well. So she has some responsibilities she's very, very eager to. And I can tell she's actually quite ashamed at her behavior, and she's hoping to get help, Your Honor. So she's asking for the chance to be released and prove to the court that she can get herself to that program and follow through on that.
Was she originally on a PR bond?
Yeah, she had bond violations, Your Honor.
Yeah, that's what I thought. But she was on a sober list.
Yes.
All right. And then had the violations. All right. Anything from the people regarding this?
Your Honor, if the court is considering releasing her, the people would request a scram.
When would you get yourself enrolled in the program?
I am enrolled.
You are enrolled?
Yeah, I had an appointment on the 28th and I couldn't attend because I was here, but they're just waiting for me to get out so I can get back.
And that's the Trinity Addiction?
Trinity Health is 3 days a week. Yes. And it also includes testing, Your Honor.
What I'm going to do is I'm going to give you a shot.
Oh, thank you.
It's going to be up to you though.
Okay.
So I'm going to reduce her bond to a personal cognizance of $25,000 bond.
Thank you.
Defendant is to be placed on a scram tether unit prior to her release.
Thank you, Your Honor.
Right?
Thank you.
I'll see you at that.
Thank you.
Right? And Mr. Bernstein is right. If you violate, it's going to be a jail sentence.
I understand.
Thank you. Court does call the case, People versus Brittany Williams.
Haley said on behalf of the people.
Yes, Your Honor, we plead this honorable court.
I told you to call it. I told you not to talk to him, but I said I didn't want his case called either.
Oh, I missed that part.
No, him and Mac, they're supposed to wait here all day. No, it was him and Mac.
Oh.
That was.
No, first time.
No, Sam could go. Yeah, Sam's fine. All right,
thank you. Brandon Bird on behalf of Brittany Williams. Ms. Williams, can you please take your full name?
Brittany Marie Williams.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, you are unable to proceed.
Respectfully request dismissal, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you.
The honorable court, have a great one.
You do the same. That's it for you?
That's it for me today.
Really?
Yeah, really.
It's always a pleasure seeing you every day. No, I mean that from the bottom of my little heart. All right, take care. Court does call the cases of the people versus James Dragon.
Alexander on behalf of the people, Your Honor.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record.
James Patrick Raggett III.
Thank you.
And Your Honor, today's date and time set final settlement conference on our file, and at this time, people are unable to proceed.
In both cases,
Just the 920.
923. Okay, go ahead.
Move to dismiss, Your Honor.
People being unable to proceed, case ending in 0923. That case is dismissed. That's what that.
On the other file, Your Honor, that is the high BAC case.
Yes.
Your Honor was willing to have the file today, given the potential of a dismissal today. He's being held on bond denied because of the domestic violence case that was picked up. Given that the case has been dismissed, I would ask that the court consider reinstating his personal bond. He has been on a scram tether since January of this year. He's had no alcohol or drinking or tampering violations on that tether. He was just picked up on again, the domestic violence case. If the court is willing to release him today, he is asking the court to consider giving him a sober link. He, as I said, he did have no violations on the scram. He's been on it, well, been in custody for a few weeks now, but before that, no violations on the scram. He works with bikes, like literal pedal bikes. He runs both the
As opposed to what other kind?
sometimes I think electric bikes. Yeah, there you go.
Motorcycles. Sometimes
Yeah.
people think motorcycles.
So he works at a place that sells bikes, and he also runs a nonprofit for children. So teaches young people how to ride bikes. So he's asking a sober link just because the scram can get in the way of pedaling.
Can get in the way of pedaling?
So I have more information if the court wants. So because he has tattoos on his legs, the device that detects.
No, you keep going because I don't know who's buying it, but go ahead.
The device that detects or tracks the skin has to be on clean skin, I guess, for lack of a better phrase. No, non-tattooed skin. And the only place that can be is the inside of his ankle.
Oh. Okay.
The chief will request the script. He's done very well on it, and I want him to continue to do so.
They no longer have it on you, sir.
No.
No. All right. We are set for September 17th on this case.
Yes, Mr. Raggett is going to get a assessment done. I think we set it out that far. So if he were to be released, then he can get that done, get it to the people for consideration of a reduction.
All right. What I will do is I will reinstate his previous bond. However, he has to be on a scram tether prior to release. I understand that he's done very well while on the scram. But I'd want that. I do recognize also that his blood alcohol was a 0.31. So a scram tether is justified in this case. All right. All right.
Thank you, Your Honor.
Thank you. You're gonna need this. Court does call the case of the people versus Keith Davis.
Ally's done on behalf of the people, Your Honor.
What?
Okay.
You know, I told you, leave that. They never listen. They never listen.
Judge, for the record, I'm listed on the multiple names, so it's not their fault.
I see.
It's not their fault. Good morning, Judge Simpson. Hugo Mack appearing with Mr. Davis. And just a record, I want to know my client's wearing long pants today. And
Yes.
In recognition, the National Weather Service did cancel the flood warning. So
Okay.
we're in good shape here.
Good shape. Your name, sir?
Keith Davis.
All right.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, make a motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you so much, Judge.
All right, thank you.
Have a great day.
Thank you. Take care. The court does call the case, People versus Paris Calloway.
Conrad Silver on behalf of the township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Calloway. Mr. Calloway, please state your name for the record.
Good morning, Paris Calloway.
Thank you.
Your Honor, this is the date and time set for final settlement conference. People are unable to proceed. I did have a plea offer with Mr. Calloway as well, on the record that he's rejecting that plea offer.
All right.
Is that correct, Mr. Calloway?
Yes.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without.
Thank you, Your Honor.
Thank you.
Court calls case People versus Maurice Cahey.
Conrad Silver on behalf of Eastfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cahey. Mr. Cahey, please state your name for the record.
Maurice Cahey.
Thank you.
This is the date and time set for final settlement conference. People are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you. Court calls case of the People versus Thomas Bennett.
And on behalf of the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Have a great day.
Thank you.
Court calls the case People versus Nicholas Bonsanek.
Ally Zend on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Why is she?
He's in there. See?
Yes.
Oh, it's my Kiwi. Yeah.
Oh, sorry, Assistant Public Defender Natalie Pate now with and on behalf of Mr. Bosnack. Mr. Bosnack, do you mind turning on your microphone and stating your name for the court if you can hear us?
Full name Nicholas Michael Bosonic III.
All right. Thank you, sir.
Your Honor, today's
Thank
date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. All right. Sir, thank you very much. Take care of yourself.
Thank you, Your Honor. Thank
And
you.
all those down in Kiwi land. Eh?
Thank you very much.
Take care.
Thank you, sir.
You have a good day.
You too.
Bye-bye.
Court calls the case People versus Jason Brooks.
Ally Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. State your name for the record, please, sir.
Jason Brooks.
And Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir. Thank you. Court calls the case of the People versus Shimona Byers. Yeah,
Ally Zend on behalf of the people, Your Honor.
I think it's Jay Jamoya. I give up.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Byers. State your name for the record, please.
Deja Moye Byers.
Deja Moye.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Court does call the case People versus Ashton Ebler.
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ebler, who is approaching. Please state your name for the record, sir.
Ashton Ebler.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you. Court calls the case of the People versus Marquand Gracie.
Allie Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Gracie. Mr. Gracie, please state your name for the record.
Marquand Q. Gracie.
Thank you.
Your Honor, at this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you.
Court calls the case People versus, is it Hishar Isa?
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr.
Good morning, Your
Issa,
Honor.
who stands to my right.
Good morning, sir. State your name.
Shar Isa.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court calls the case of People versus Douglas Lee.
Allie Zend on behalf of the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Douglas Lee.
Thank you.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court calls the case People versus Jaquil Lloyd.
Allie Zend on behalf of the people, Your Honor.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lloyd, who stands to my right. Please state your name for the record, sir.
Jaquila Lloyd.
All right. Put your hands up.
I'm sorry.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you,
sir. Thank you.
You sit there.
Why'd you shake her hand? She didn't do anything. No, I'm kidding. Court calls the case People versus Adriana Taylor Hamby.
Allie Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor Hamby. Say your name for the record.
Adriana Taylor Hamby.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Thank you, Sandy. Take care.
Thank you.
Bye. She on her way. Bye. Brennan. Court does call the case People versus Ronald Altman.
Allie Zend on behalf of the people, Your Honor.
AMC counsel back there. Okay.
Morning, Your Honor. Don Smith on behalf of Mr. Altman.
Your name, sir? All right.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, we ask that the matter be dismissed.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you, Your Honor.
Take care. Court calls the case of the People versus Issa Awad.
Allie Zend on behalf of the people, Your Honor.
Good morning, Your Honor.
Deborah Bledsoe Ford, Jeffrey Geraldine Bledsoe Ford on behalf of Issa Awad.
Okay.
Your Honor. Oh. My
Your Honor,
client
today-
is here today. I don't know if the, oh, go on.
Your Honor, today is the date and time to have a final settlement conference. At this time, I would be asking for an adjournment of the final settlement conference. We were attempting to reach out to the victims and found out the number that we had was just for the business that they worked at. And when we were finally able to make contact, we found out that both of our victim and witness are either out of town today or getting medical treatment for something. So we would ask for an adjournment so we would have a chance to speak with them and discuss this case.
Response?
No objection.
All right. State your name, sir. 'cause you did. All right, thank you. What I'm going to do, sir, is I'm going to adjourn your case. I'll adjourn the jury final settlement conference. We'll set a new one for October 17th, 2025 at 9. And then jury selection in this case, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
All right, thank you.
Thank you.
Thank you.
Bye.
Good day.
Bye.
Thank you.
No.
Okay. So all right, no, that's fine. It's there. Oh, you printed it for
Miss Engine.
got it. Please, sir.
And that's him right there.
Okay, so they're waiting. All right. Court stands in recess. I'll stay seated. Paul, is it Gutzlaw?
Your Honor, Jillian Aiken for plaintiff.
Your name, sir?
Paul Gutzlaw.
Nice to hear. All right, where are we on this case?
Your Honor, the parties have reached a conditional order of dismissal.
Okay.
And so we can place the terms on the record.
Yes.
All right, thank you, Your Honor. This is a case for termination of tenancy, and this matter is going to be dismissed without prejudice, subject to the terms of the order. Defendant Paul Gutzlaw shall vacate the leased premises. I'm not going to put the address on the record, and shall turn in keys on or before September 15th, 2025. As of August 8th, 2025, defendant's balance with plaintiff is $3,022.13, which includes court costs of $172. Defendant shall pay the arrearage of $3,022.13 as follows: $1,069 on or before August 8th, 2025, and defendant shall pay the remaining arrearage plus the final utility bill and prorated September rent in monthly installments of $500 commencing October 15th, 2025, and continuing each month thereafter until the arrearage is paid in full. It's not in the order, but if Mr. Gutzlaw misses a payment, his account is going to be sent to collections. That will resolve that. And defendant shall comply with the terms of the lease. Plaintiff shall provide a neutral landlord reference if contacted about defendant by a prospective landlord. And then in the event the defendant fails to comply with the terms of this order, plaintiff will be entitled to an immediate judgment for possession with a writ of restitution and an order of eviction to issue immediately upon the filing of an affidavit of noncompliance with the court without hearing but with notice to defendant via mail. On the copy that I submitted to the court, it included a provision 8, and Mr. Gutzlaw is requesting that be stricken from the order. I can delete it. Okay.
Go ahead.
I can delete it and then resubmit it.
Okay.
So that it does not include that. I've provided.
What is the provision 8?
It says defendant specifically waives the 14-day notice and objection period set forth in MCR 2.602C2D. I think Mr. Gutzlaw is concerned about waiving rights that he doesn't necessarily hasn't looked into what he would be waiving.
What he waived. All right. All right.
And then I And then we did go over MCR 4.201J, but I'm hoping that can be placed on the record as well.
All right, sir, is all of that correct?
I believe so, yes, sir.
All right. Is there, just look at this. Do you have any questions or concerns regarding any of the provisions other than paragraph 8? And I'll get to that in a moment, but
I don't.
no?
No.
All right. Okay, and sir, why don't you lay out for me, what's your issue with paragraph 8?
Well, it appears that I'm giving up a 14-day notice, right? That I don't understand, and that wasn't really part of the discussion when we came to this agreement.
Okay, and that's probably because most of the time that these are coming through, that's waived. So let me, so that you understand what that, I'll give you what the legal effect is and what the practical effect is. Okay. All right. So normally what would happen if there's a violation in some respect, you would be entitled, they'd have to send you notice, you get 14 days notice regarding that before anything could happen. Okay. While that's there, the practical effect of how things work is that, let's say, just hypothetically, there's a lease violation, say the 31st, before the move out date. Say September 1st, okay, just picking a date. And they file for their judgment and order of eviction. You still have a mechanism by which you could get before the court. That's the practical effect. You just don't have that 14-day period. So if you believe they're wrong, you can file a motion with the court to be heard and you'd be heard. That's the practical effect of how this operates. Okay. So while I understand the waiver of the 14 days, not so much. Here's part of the problem and why it's also included. Okay. Because in particular on the cases such as these, where there is the move out date. All right. Technically come September 15th, because I think you're supposed to vacate by the September 6th. Well, technically by September 16th, the plaintiff theoretically, in order to get possession of the premises, would have to wait another 14 days. But what they've done is they've already given you the time to move. All right. So that's probably the best that I can explain it as to what it is and why the plaintiff would want it. Why from the tenant side, yeah, it's waiving that 14 days, but really it's not like you wouldn't be able to get before the court to have whatever issue you had heard. So
this landlord has been very unfair about claiming violations. Very minor things that could be handled by a reminder. He has levied his own fines and fees.
Gotcha.
With a rapidly escalating.
Why don't I do this? What if I did this to paragraph 8? Maybe it solves both problems. Okay. What if I just said you're waiving the 14-day notice and objection period only as to the September 15th move out date?
Fine.
So that if it's anything else, you get the 14 days. How's that sound?
I'm very good with that. Thank you.
Okay.
Your Honor.
Your Honor, that's satisfactory to us as well.
I've added that to that. I need to hand this to you guys because I'm gonna need signatures for all of that. And sir, when they give that to you, you have 3 business days from the time that I sign it to think about this. If you believe that there's some right you have in a cert, some confusion on your part, or some other type of misunderstanding, you'd have those 3 business days to think about it, file a motion with the court in that time frame. Doesn't mean I grant it, but you have that time frame to do that. Okay? Thank you.
Vote for the people.
Okay. Wallace.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Wallace, who is approaching. Say your name, sir.
Matthew Wallace.
Your Honor, we're asking you to set this for final settlement, please.
Final settlement conference will be set October 16, 2026 at 9 a.m. Jury selection, if necessary, will be October 19, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Thank you. Fine, continue. Court calls case the people of the state of Michigan versus Amy Gochak.
Good afternoon, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I do not see her on the Zoom. I was waiting to see if she was in the courtroom.
Your name? Okay, she's here.
Okay, thank you. Judge, we're asking for a final settlement conference and jury selection.
Jury final settlement conference will be set October 16th, 2026 at 9 a.m. Jury selection, October 19th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue.
All right, thank you, Your Honor.
Thank you. Court calls the case people versus Jason Heron.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Heron. State your name, sir.
Jason Heron, good afternoon.
Thank you.
It's your question pertinent to.
Oh, with the O'Leary would have retained, she said,
Come on, Perry.
first.
Sorry, Judge.
No, it's okay.
Sorry about that.
No, it's okay. It's okay.
So Mr. Heron has retained counsel or is in the process of doing so. He just informed me that she won't be back until the end of this month.
Yes, Tina Saxton.
Who?
Tina Saxton.
Gone.
She's on vacation.
She is gone. I guess.
She is gone?
Yes, she is actually.
She left the country, didn't she?
Surprisingly, I know her schedule too. I guess we all do. Where'd she go? She go.
She said somewhere without phones.
Sounds nice.
She said somewhere without phones. Okay. I think we set things for her. Golly, I want to say we did a Wednesday, September 2nd.
She said that.
Pardon?
Said that 8:31 will work. She says she has a trial in October 6th. So any in between that, she requested.
So you tell Miss Saxon. No, I'm not. I'll pass that message myself. So when she told you August 31st would work?
Yes, she's in text.
Then what I will do without objection is I'll adjourn this to August 31st, 2026, 9 a.m. or 1 p.m., excuse me. Okay. Great. Thank you. And that's all right. So quiet. Thanks. Just go on.
What about the video?
Court calls case People versus Harmond Rowland.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, this is Public Defender Lauren Kearney. On behalf of Mr. Holland.
Rowland.
Good afternoon. Good
Your
afternoon.
name, sir?
Good afternoon. This is Harmon Rowland.
All right. What are we doing?
We're asking for this for final settlement, Your Honor.
Jury final settlement conference will be set October 16th, 2026 at 9 a.m. Jury selection, October 19th, 2026 at 8:30. Both of those proceedings are in person. And bond will continue. Thank you. Court does call the case of the People versus Eric Buckner.
Citizen Public Defendant Nicholas Bukovich on behalf of Mrs. Buckner, who's appearing via Zoom.
Mr. Buckner, state your name for the record.
Eric Buckner, how you doing today, Your Honor?
I'm doing well. You?
I'm hanging in there.
Okay. All right.
Clear on behalf of the brothers. Before the court for a review hearing, there has been some changes that I provided information to the court. Mr. Buckner does have a balance of the $1375. He's made no payments. He does have a current payment plan arrearage of $504. He has provided me with documentation from his doctor. He has an injury from a dog bite that he was supposed to be getting surgery for. That surgery got put off. So what Mr. Buckner has provided me is that he has an inability to work, and that is not expected to change at December 31st of this year. However, the documentation that I have is a little bit dated. He was going to get me some more updated information, although I'm not sure that it's going to change. So that's what I have for his noncompliance with the payment plan. I also indicated to the court that he got enrolled in the domestic violence program, but had not started it due to financial, because it does cost for the class. Since then, though, Mr. Buckner did start that class, and I have verification of that today.
Okay.
So he has made some progress with that. Given that he has made some progress with the class, and I have the documentation regarding the monies, probation at this time is just asking that all conditions continue with a next scheduled review hearing date set for October 19th, 2026 at 1 p.m. I would ask that Mr. Buckner continue to try to get me something more current regarding his medical.
Okay.
Okay.
You hear that,
Okay,
Mr. Buckner?
no problem. Yes, Your Honor.
Every month, so like he should.
Yeah, and the defense has no objection to that recommendation. I did speak to Mr. Buckner last week, and I know he is working on getting the updated medical records, but obviously sometimes getting anything from a medical facility can be a very slow process. But I do know he is aware, and he's been working on it as we spoke about this last week.
All right. What I'm going to do is I'll just order that he's to provide it by the 31st, but I understand that there may be a delay. So he's to provide medical documentation on or before August 31st, 2026. I'll continue all terms as previously ordered. I'll set his next review hearing for October 19th, 2026 at 1 p.m. All right. Okay. Thank you.
Thank you.
Thank you. Let's go.
Court calls case People versus William Fridge.
Claire, on behalf of probation, Your Honor, Mr. Fridge is scheduled before the court for a review hearing. I know that this court had set the review hearing out because he didn't appear at the last one.
Yeah.
And I do know that the issue with that, Your Honor, is that he was having to miss work to come, and he is supporting his family and two babies. So I do know that he was also behind in payments. Technically, Your Honor, his end date with probation is in September. The probation's recommendation was to refer his balance to collections, and discharge him with improvement. Mr. Fridge has come a long way since he was before this court. Given that he's not here, I'm not sure if the court would still follow that recommendation.
What I would do is what I'm gonna do is I'm gonna waive his appearance, refer the balance of the funds to collections, and I will discharge him from probation with improvement.
Okay. You're right.
I'm aware that he
Him and make
has.
sure that he sets up a payment plan with collections.
All right, very
Thank you.
good. Court calls case People versus Roman Williams.
Afternoon, Assistant Superintendent Laura Perry on behalf of the Williams. We did, well, oh, he's here, right?
Okay, there he is. Sir, state your name, please.
Roman Williams.
Teresa Player on behalf of the probation, Your Honor. Mr. Williams is scheduled before the court for a review hearing on 2 cases. Your Honor, Mr. Williams had a balance of $370 on his restitution balance. His total owing in case ending in 1243 was $1,445. He had indicated to me the last time that I spoke with him that he would have that $370 paid on or before today. It has not.
Oh, okay.
I do know, Your Honor, that this court had indicated once restitution would pay that the court would look at his balances regarding costs. However, I don't see that $370 is paid, so I would ask that Mr. Williams provide an update to the court as to why that's not paid today.
Mr. Williams? I can't hear him. He's unmuted. But I don't think he's connected to audio. Oh, he's out. Okay, I'll pass that. Those matters. Court does call the case Field versus Darnett Blackwell.
Washington State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge J. Simpson presiding.
And good morning, folks. Court does call the case of the People versus Quinte Jenkins.
Good morning, Your Honor. Ashley Londy-Feltis for the people.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Mr. Jenkins, who is present and consents to appear via Zoom. Mr. Jenkins, unmute. State your full name.
Hello, my name is Quinte Jenkins.
All right. This date and time set for an evidentiary hearing.
That is correct, Your Honor. Thank you for allowing us to appear via Zoom. As I indicated in an email to the court staff earlier today, one of my witnesses is not available, so I am not able to proceed at this time.
All right. Actually, I was going to let you appear via Zoom. I was going to make Mr. Zaid come in.
Oh, no, Your Honor. Oh, no.
I said, no, that's not fair.
Well, I certainly appreciate the accommodation as well, Your Honor. In light of that information, we are respectfully requesting the court dismiss this matter.
All right. This case is dismissed pursuant to the defendant's motion. That is without prejudice.
Thank you, Your Honor. Have a great day.
Thank you, Your Honor. Have a good day.
Just take care.
Thank you, Your Honor.
You're welcome, sir. That was it. Okay. This afternoon. Really? Good. I may come back. Court stands in recess.
What happens when a defendant gets chance after chance, but keeps coming back to court with the same problems? This hearing was filled with bond violations, missed appearances, treatment requests, drug testing issues, and judges making it clear that courtroom rules are not optional. One of the most serious moments came when the court addressed a defendant who had tested positive for amphetamines and cocaine. The defense argued that the amphetamine result could be connected to an old prescription. The defendant explained that he had taken Adderall for years and claimed his doctor had recently stopped treating him. He also said that some of the medication had been kept by his mother while he was homeless. But the judge had a major problem with the explanation. The court wanted documentation. If there really was a prescription, the judge wanted proof that could be provided to community corrections and to the court. Without that documentation, the explanation wasn't enough. And then came the critical decision. The judge ordered the defendant remanded into custody, while leaving the door open for the defense to provide the prescription information and ask the court to reconsider. But that wasn't the only tense moment. Earlier in the hearing, another defendant was facing allegations involving retail fraud from 2 different establishments. Prosecutors described roughly $700 worth of shoes taken from one store and approximately $1,700 worth of alcohol and household items taken from another. The prosecution also raised concerns because the alleged incidents happened while the defendant was already under supervision. The defense pushed back, explaining that the defendant had since become compliant, had appeared in court, completed treatment, and was trying to rebuild his life and find employment. The judge ultimately chose not to find him in violation at that moment, but imposed stricter testing requirements. Instead of testing only every other week, the defendant was ordered to test weekly, including through an approved facility if necessary. The message was clear. The court was willing to give him an opportunity, but that opportunity came with conditions. Then came another courtroom reality check. A defendant who had failed to appear faced the possibility of a warrant and a substantial bond. In another case, the court made it clear that repeated failures to appear would have consequences. One defendant had already accumulated multiple warrants, including warrants connected to missed settlement conferences,